Welcome. You're watching Buckingham Business Review. I'm Bernie Wolford, your host, and our video magazine is about the intersection of people, strategy, and tactics. I am extremely pleased to have a guest with us today that I've anticipated having on the show for quite some time, Mr. Kevin Skedsvold. Let me read a brief bio on Kevin and then encourage you to read the extended version on the various websites in which we post. Kevin is the managing partner of Skedsvold and White. He is member of the Chairman's Advisory Committee for the State Board of Workers' Compensation. He's a licensed instructor of continuing education from the Georgia Insurance Commission and the only Georgia attorney who is instructing the Wickstrom Insurance and Risk Training, a nationwide internet-based insurance training platform. Kevin is AV rated by his peers in the bar for ability and integrity, and his firm is a member of the Council for Litigation Management, formerly known as the Council for Ethical Billing, having been recommended for membership by a client. Kevin, I know you're very busy. Thank you so much for taking time out of your schedule and treating me and treating our viewers to an episode or two of Buckingham Business Review. Welcome.
Thank you for having me.
Let's start out at 40,000 feet. Why don't you give our viewers a bit of a thumbnail sketch of your firm, Skedsvold and White. Who are you guys? Where's your niche in the marketplace? What are your steeples?
Skedsvold and White's been in practice for approximately 7 years. I've been practicing law for 24 years, and we are a small firm specializing in insurance defense and in business litigation. My particular focus is in the area of workers' compensation defense. I represent employers and insurers when they have workers' compensation concerns.
Okay, so you're on the employer side. You're not one of these guys that comes on in the wee early hours of the morning trying to get the other side to get representation. You're strictly employer?
No, but without those guys in the late night commercials, I probably wouldn't have a job. So
I understand that.
Yeah, we represent the employers and not the injured worker.
Okay.
Too often the employer is left out of the picture, and their motives are maligned. They have no idea what to do, and really they have no more of an experience with the workers' compensation system than do the people that they employ.
Sure.
And they're assumed to know a lot more than they actually do, when their core competency is their business and not handling a workers' comp claim.
Okay. Now, obviously, you're not the only law firm in the state of Georgia that does this. How do you differentiate? What are your keys to success that makes your phone ring as opposed to other options?
Well, first off, we're proactive instead of reactive. When we are involved with our clients, we want to be involved very early on. We want to be part of the team. Before there's a problem, before there's litigation, we want to know what our clients' concerns are and how we can address them, so that if litigation does occur, that they're prepared for it. They can take advantage of the opportunity when that matter arises to act quickly and to conclude it as quickly as possible in their best interest. So that's really how we're different. Primarily, I like to think that we're more accessible. Mm-hmm. As a small firm, we are all accessible to our clients, and my clients have my direct dial number, they have my cell phone, and they call me at any time with whatever's on their mind. And we need to be there to help them when it's important to them, not when it's important to us. So we're not a 9-to-5 operation.
Okay.
We're looking for a strategy to help educate them so that the problem doesn't occur. And as a result, our focus isn't on maximizing our legal bills. Mm-hmm. Our focus is on actually saving money for the client, because we prevented the problem from occurring in the first place. It may never arise to litigation.
Okay, makes sense. So I can only surmise that quite often the horse is already out of the barn, to use the cliche.
Yes. When
a lot of attorneys' phones ring, and it sounds like you're providing some resources, some guidance, some education on a sort of a preemptive, ongoing basis. Am I hearing that correctly?
Exactly.
Okay.
What we try to do is to provide some educational opportunities. Really, they are going to be tailored to what our clients do. What type of business do you have? What type of exposures are you going to see? And what can we do to minimize it? I mean, you will not prevent every accident from occurring. You will not prevent every lawsuit from coming up, but you need to be properly positioned to take advantage of the situation when it comes to you.
Okay, makes sense. Your logo, motto, rallying cry is aggressive, effective, and ethical. I like that. That speaks to me. But what does it mean to you internally and to your client base? Those three words.
It has to be the right mix of all three, actually.
Okay.
Anybody can be aggressive, or anybody can say that they're aggressive. But if your aggression is limited to turning every case and every phone call into a battle, you quickly find that it's a diminishing commodity.
Sure.
Also, you find that you're predictable. And if you are predictable, the other side can anticipate and can take advantage of you when you do exactly what they expect you're going to do. Anybody can be aggressive, but if you're not aggressive with a purpose, and aggressive doesn't have to mean hostile. Aggressive simply means we've got a plan. Mm-hmm. We will plan our work, we'll work our plan, and we'll be deliberate about it. So aggressive just in terms of being deliberate and moving the case as quickly as possible, because most of our clients don't want to be in the litigation arena very long. We need to get them out as quickly as possible and as cheaply as possible for them.
Okay. And obviously effective and ethical speaks for themselves, but terms that speak for themselves. But is it going into every case, I know every case must be different, but is settlement pre-trial usually the objective, something that's a win-win, that's agreeable to everybody, or is that a pipe dream that it quite often ends up in some litigation, in some courtroom?
It's not my call. Whatever we're doing, what our clients need for us to do.
Okay.
If it's in their best interest to get the matter resolved and get it settled, yes, we do that.
Okay.
But we're going to do it in a way that is to their advantage. If there's an exposure for you and you want to resolve it, yeah, you want to resolve it, but you don't want to have to resolve it 3 years from now after you've spent thousands and thousands of dollars in legal fees.
Makes sense.
You need to be able to know early on what are the risks, what your case is, the strength of your case, the weakness of your case, as well as the strength and weakness of the opposing side. If you know that, you know exactly where you need to be going. That's what we pride ourselves on, is preparation and knowing what we need to do. And for me, that's where the ethical part comes in, is I need to be able to tell my clients, look, we can litigate this for X number of dollars, or we can settle it for a fraction of that. And if I'm not doing that, then I'm not watching out for their interests, I'm watching out for mine.
Sure.
So I need to be able to tell them what to expect and move along the case as quickly as possible and get them out and back to their business.
Makes sense. Well, we are visiting with Kevin Skedsvold, and Kevin has graciously agreed to do several segments with us. So we're going to, in our next segment, take a deep dive into some of the cases, perhaps names hidden to protect the innocents, as they say, but to really put some meat on the bones with specific illustrations of some of the work that Kevin and his associates are doing. So we hope you will join us again on the next segment of Buckingham Business Review.